Good afternoon, everyone, and thank you for being part of Mills & Reeve's live Foundations webinar programme, covering legal issues affecting the construction industry. I'm Martino Giaquinto, partner and head of the firm's construction disputes practice. And I'd like to introduce you to today's speakers, Alison, Garrett, and Kate Warren. Alison is a senior legal advisor with over 30 years of experience in advising on and dealing with all types of construction-related matters. Kate is an associate in our construction team, having first trained and then qualified with us. Kate advises on all aspects of construction law, and certainly over the last year or so has spent a large amount of time advising specifically on cladding claims and remedial contracts. Over the next 45 minutes or so, Alison and Kate will outline the present position in relation to fire safety in buildings and the changes proposed in the Building Safety Bill and the Fire Safety Consultation, discussing specific issues to be considered in contracts for the removal of unsafe cladding in light of the scale and extent of the use of ACMs across the country. And finally, look at issues of limitation and claims in relation to fire safety generally, with a particular focus on cladding. Thereafter, all of us will be available to take part in a Q&A. You can submit questions during the session by opening the Q&A box, which should be at the bottom of your screen, typing in your question and submitting your question to us. A recording of the session is taking place and will be available after the session is concluded. So quite a lot of material to get through, so let's make a start, and I'd like to hand over to Alison.
Thank you, Martino. Hello, everybody. As Martino said, I'm going to talk about the current position, where we are now, and I'm going to look at the government advice that has been given in relation to existing buildings in respect to fire safety, particularly in relation to cladding, and linked with that, the Building Safety Fund and the Wake-in Watch and the EWS1 forms. I'm then going to have a look at the legislation which has either come into force or is planned in respect of the use a ban on combustible materials and external walls, and the requirements for sprinklers and way signage. And then I'll finally touch on the Building Safety Bill and the Fire Safety Consultation. Now, they both came out in July, the 20th of July, I think. Both are very detailed documents. I'm not proposing to go through them line by line, but what I'm hoping to do is to give you a flavour of what they say and an indication of the government's thinking long term about fire safety in residential buildings. Next slide. Dealing firstly with the government advice regarding particularly cladding on high-rise residential buildings. The government has been issuing advice and guidance with regard to this, and the last one was published in January of this year and consolidated previous advice. It's aimed primarily at building owners of multi-storey, multi-occupational residential buildings, and relates primarily, but not exclusively, to the external walls, the cladding, for want of a better description, or a generic description. And broadly speaking, the government is mainly concerned with the removal of cladding in what they consider to be materials that are unsafe on buildings over 18 metres high. And you will see that there's a theme that runs through what I have to say, where the limits are 18 metres or lower. Now, when you think that Grenfell was actually over 67 metres tall, the government has shown it's obviously very concerned about cladding at a lot lower level than that. Next slide, please. As a sort of carrot to encourage the removal of cladding, perhaps a bit more than a carrot when you're talking about the sorts of sums that we're talking about here, the government has introduced a building safety fund. It first provided £400 million to that fund about 2 years ago, just over 2 years ago, for the remediation of high-rise in buildings, residential buildings, which were again over 18 metres tall, with unsafe ACM cladding only in the social housing sector. Then last year it provided a further 200 million for the remediation of unsafe ACM cladding in the private sector. And earlier this year it found another £1 billion for unsafe non-ACM cladding in high-rise residential buildings in both the private and social sector. The government's position is that it is not just ACM cladding that is dangerous or unsafe, non-ACM cladding is also potentially unsafe. The deadline for showing an interest in the Building Safety Fund has expired, but Kate will talk a little bit more about what the next steps are that are required once once a party has shown an interest in that fund later on in the talk. Next slide, please. The two other things that I wanted to mention in relation to this, perhaps focus a little bit more on the owners of private sector properties who find themselves in a position where they are living in a building where the government's advice or guidance is that the external walls, the cladding is unsafe. As a temporary measure, many introduced round-the-clock provision of fire security to patrol those buildings, search for fires and raise the alarm, whilst they decided how to address the issue of the external walls. Unfortunately, that hasn't always been quite as temporary as perhaps residents had hoped for, and there are a number of buildings which are still having to have what is known as a wake-in watch, an expensive exercise for the residents. Next slide, please. Another issue that the residents were facing was that, or they still are facing, is that it's very difficult for these to remortgage or to sell these properties because lenders, quite understandably, are not particularly keen on lending money in relation to them. To try and overcome this issue, which seemed to taint all, was tainting all high-rise residential buildings, whether in fact they had unsafe cladding or not, the RICS, the Royal Institute of Chartered Surveyors, introduced at the end of last year a scheme called an EWS1 form, which was to have a tick box basically saying whether the cladding was, whether the building was safe or unsafe, or the cladding was unsafe or unsafe. There's no statutory requirement for this. And as I say, the purpose of the form is to address the fire risks of external wall systems. And the intention was that such a form would be valid for 5 years. And I think we can all see how that form, the intentions of that form would be a good idea. It would enable residents to move on a bit. It would stop properties being tainted as such. The idea was the form would cover the whole building so that there would be intrusive surveying of all of the building in one go, not individual flats. However, it has faced some problems to date, both because it's obviously expensive and many of the residents have already incurred substantial costs in terms of a wake-in watch. And also it can be difficult to obtain. Kate will mention this in a little bit more detail when she speaks, but fire safety experts are thin on the ground at the moment. And even if it's possible to get hold of one, there is or can be some reluctance for some of them to want to sign such forms. I'll now turn to look at actual legislation. So next slide, please. And by that I mean looking at the legislation that's coming into force with regard primarily to new builds. In December 2018, the government introduced a ban on the use of combustible materials in the external walls in high-rise residential buildings. And by high-rise residential buildings, they meant or mean at least 18 metres above ground level and include one or more dwellings. So, for instance, if you were to have a situation where you had an office block with a penthouse on top, that would be one or more dwelling and the whole building would have to comply with the ban. Or constitutes an institution. Now, the definition of institution is broadly speaking, and I am speaking quite broadly about this, the situation where someone sleeps on a regular basis in accommodation such as a care home, a hospital or a school. And then or contains a room for residential purposes. So broadly speaking, we're talking about student accommodation there because hostels, hotels and boarding houses have been specifically excluded. As I say, this applies to new buildings. It also applies to a material change of use of a building. So in my office block example, if there was to be a change of use to add a penthouse on the top floor, that would end up resulting in the ban applying to the whole building. Next slide, please. And the government has been consulting on extending the ban. The consultation was issued in January of this year. It was due to expire in April, but was extended to May because of the COVID situation. But their proposal is to extend the ban to include hotels, hostels and boarding houses, and it seems likely that that will come into play. And they're also consulting on extending the ban to buildings with at least a story 11 metres above ground level. Now, in the last 6 months, we've all become very familiar with what 2 metres looks like. If you times that by 5.5, that's not that high. So you can see that the government is gradually, and this is a theme that will continue to be the case as I talk about other things the government's considering doing. There's a theme of lowering the level quite dramatically originally from the height of Grenfell, which was higher than the original bans, from 18 metres, now perhaps looking at 11 metres in relation to some things. The consultation talks about other things as well, but one of the things that is perhaps quite interesting is that it's suggesting the banning of metal composite materials with a polyethylene core on buildings of any height at all. And sadly, or interestingly, that would include the cladding used on Grenfell. So that's where we are with legislation regarding the ban on combustible materials and external walls. Next slide, please. The government is also, or from next month actually, there's the introduction of a requirement for sprinklers to be fitted throughout blocks of flats with a top story of more than 11 metres above ground level. Those sprinklers will need to be in the individual flats. They won't be required in the common parts if it can be shown those areas are fire sterile. And there's also an introduction of way signage. That's both floor identification and flat indicators. Again, in blocks of flats with a top story more than 11 metres. And the purpose is to aid fire and rescue services should they require it. Next slide, please. And then, as I said, I'd talk a little bit about the Building Safety Bill and the Fire Safety Consultation. These were both issued in July and they're both quite detailed. And my first slide actually refers to what is meant by higher risk buildings. And that's because the Building Safety Bill talks about that. In actual fact, it doesn't define it. The only reference you can find at the moment is in the explanatory notes. But this is what a higher risk building is likely to mean. And it's important because it's a term that's used, or equivalent term used, in both the Building Safety Bill and the Fire Safety Consultation. And it's also interesting, if you're a lawyer, at any rate, that it's a slightly different definition from that used in the ban on combustible materials, or at least it is at the moment. It's 2 or more dwellings, or 2 or more rooms for residential purposes, but not care homes, not hotels, hostels, hospices, or guest house, but it is student accommodation. And it is a building with a top story of 18 metres or 6 stories, whichever is reached first. So bearing that in mind, I'll move on to talk about other aspects of the Building Safety Bill. Next slide, please. Key things from the Building Safety Bill is that the government clearly intends to beef up regulations and requirements for safety in high-rise buildings. And there are themes running through the Building Safety Bill, including this concept of a golden thread, which is pretty much that from inception to occupation and beyond, there will be a chain of responsibility and information available to anyone who needs to investigate what has been happening. Firstly, there's the introduction of a building safety regulator. That's a new position. It will be housed within the Health and Safety Executive, and it will cover building control authority for higher risk buildings. It will have more teeth than the building control authorities have had in the past. There will be a register of building inspectors and building control approvers. There will be greater responsibility for those designing, constructing or refurbishing buildings, including those operating under the CDM regulations. And on that note, the Competent Steering Group has issued a report in the last week or two, the final report on setting the bar of competence in the construction industry. And for those of you that are interested, you'll find a blog on our construction blog in the last few days by one of my colleagues, Bogdan Opry, on that. There'll also be a new Homes Ombudsman, and there is also the introduction of an accountable person. Now that is likely to be the building owner or somebody with repairing obligations for the common parts. And they will have a series of obligations in relation to higher risk buildings during primarily their occupation. Next slide, please. And briefly, those obligations will include registering the building and applying for a building assurance certificate that the building is safe, appointing a building safety manager, basically to check regularly that safety requirements are being met, assess the building safety risks and manage them, and keep up to date a safety case report, which will include the safety risks and how they're being managed, and also keep certain information. Next slide, please. That leads me to the fire safety consultation. There is a bit of overlap between the bill and the consultation, and the notes that I have seen suggest that the government is aware of that. But the fire safety consultation broadly is to deal with the non-domestic parts of residential buildings. It arises out of the Fire Safety Order, that's its abbreviated name, that was issued in 2005, which introduced the concept of a responsible person, again, often a building owner or somebody with a legal interest in the building, who has been around since 2005. The consultation is suggesting that that person or people, because you can have more than one in one building, are identified, provide certain information, and that there is an increase in their duties. The consultation is also looking at the quality of fire risk assessments and suggesting that they be improved, that there be consultation between the fire and rescue service and building control bodies, and that there be duties of maintenance on a number of people, including the role of residents, not, for instance, to block fire escapes with bicycles or the like. Next slide, please. Last, we just want to have a look a little bit at what those extra duties of a responsible person may be. And they're broadly in relation to higher risk buildings again. So those that I mentioned earlier that are above 18 metres or 6 stories. And they involve providing information to the fire and rescue services, providing a premises information box on site which contains relevant fire safety information, that they will check the lifts monthly, that they will draw up and keep under review evacuation plans and a list of residents who require assistance to evacuate. and that residents should receive safety information. They also have provision for the check-in of self-closing fire doors, and the check-in of those doors is set out in quite a lot of detail, and varies from over 18 metres and between 11 to 18 metres. And there also a suggestion that there should be way signage on buildings over 11 metres. Now, this consultation is now closed, so it'll be interesting to see what the government has to do next. But it is quite clear, and there's a clear running theme, that they will continue to pursue the issue of fire safety, and that it will apply to buildings a lot lower than perhaps what some people might have considered a high-rise building in the past. Over to Martino.
Thank you very much, Alison. And it seems that the draft legislation, the consultation papers that you've ran through seem dense and no doubt complicated, and like an onion will need to be, those layers need to be unravelled and digested and understood in due course. So thank you. So I'm now delighted to welcome Kate to her first Mills and Reeve webinar. Kate is going to talk about the contracts needed for the removal of unsafe cladding. Kate, over to you.
Thanks, Martino. So yes, I'm going to talk about in this section 4 key aspects to be considered when entering into building contracts for remedial works to cladding. And these are the timing of the works, how the works are being funded, various specific risks and requirements that we recommend are dealt with at contract stage by potentially a schedule of amendments, and some other key documents, some of which Alison has already mentioned previously. So first, in terms of timing, there are a number of competing aspects for cladding contracts. First of all, you have government guidance and very much a push that this remedial work is carried out as quickly as possible. This has included the government sending some fairly strongly worded letters to building owners, including deadlines for when they expect works to commence. And very much the push is that even if it's not a legal requirement now, that they should be carrying out those works as soon as possible. Second, you have the fund requirements. As Alison mentioned, the time frame for registering your interest in the funds has expired, but they haven't yet confirmed whether the funds are being applied to each individual applicant. And there are some very tight deadlines in order for building owners to be eligible for the fund. The first one being that building owners need to have chosen a contractor and submit a quote for that contractor to the government by 31st of December this year, and then for works to start on site by March 2021. This, whilst everybody understands the interest in doing this quickly, this can be difficult when there are other competing aspects, such as, for example, Section 20 process in relation to residential buildings. This is a process that freeholders need to go through if there is a chance that they may need to recover sums from the leaseholders in order to carry out the works. Given that there has been no guarantees or confirmation from the government in terms of funds yet, that therefore means that pretty much every cladding contract where there isn't a claim or some other aspect of funding, that freeholders will need to carry out the Section 20 process just in case. There are a number of steps to the Section 20 process, including various consultations with the leaseholders, with them being given the opportunity to consider the contractors who are proposed and to put their own names forward. And this can take, even if it's done very swiftly, around 3 months to complete, which, as you can imagine, causes some problems with the 31st of December deadline that the government has put in place. Next is how claims may impact on the timing. Often a building owner where they have remedial work that need to take place may have the opportunity to decide whether or not they progress a claim before carrying out the works, but in these circumstances claims take a long time, often take a long time to work through, and with deadlines that are being proposed by the fund and the pressure that's being placed on building owners by the government, often building owners may feel that they have no choice but to carry out the works and then deal with claims later if necessary, or to finish dealing with that claim as time goes on. Another aspect that can make it difficult to start the works quickly is simply the availability of contractors who can do this type of work. Obviously, with a large number of building owners trying to contract for remedial works up and down the country, these contractors are very busy at the moment, which can make it difficult to fit in with the timings that are being imposed. Plus, due to the nature of cladding contracts and the fact that a lot of the works is reliant on the cladding materials, there can be quite a substantial lead-in, particularly when the materials have a high demand at the moment due to the number of cladding contracts taking place. Next, I'm going to talk about some of the things to think about in terms of money for cladding contracts, and I've separated these into 3 key areas. Funding, and it may be that your funding is coming from a government fund, from an outside source, or possibly from a settlement arrangement that's been agreed. Claim recovery, and uncertainty, which is, as we all know, can be an issue with all building contracts, with not knowing how costs may increase during the works. In terms of funding, there are a couple of aspects that we suggest are considered when drafting the contracts with the builder to make sure that any key requirements are taken into place, particularly in relation to the payment terms. For example, if the funding agreement includes a 10-day drawdown period, this may need to be taken into account to ensure that payment terms of the building contract do not make it impossible to carry out this process first. Additionally, some drawdown requirements under the funding agreement may require certain documents to be provided to the funder, and it's important to ensure that they are also included within a building contract so that that can be passed down. There may also be some sign-off requirements in terms of inter-applications, or particularly in terms of any variations that occur during the works, and it needs to be ensured that any building contracts or appointments take any requirements of the funding agreements into account. In terms of claim recovery, one of the things that's important to consider is whether there is any need to give the contractor or consultant team who completed the original works the opportunity to remedy any mistakes, and whether that should be taken into account before appointing a contractor to carry out remedial works for employers. Another aspect is mitigation. As I mentioned, it may be that the claims are ongoing and they have not been resolved at the point when employers are carrying out remedial works, and therefore it's important that any evidence or justification is collected in case there is an argument later on in a claim whether or not costs were properly mitigated, or whether they were allowed to increase on the basis that an employer thought they would be able to recover them further down the line. In terms of uncertainty, as I mentioned, this can be difficult on all building contracts, but in my experience, I found that it's particularly important to look at the prelims on these, because the nature of cladding contracts with high-rise buildings and the need for scaffolding can mean that prelims are a substantial part of the cost for the cladding contracts, and therefore it's important to consider the breakdown for this and how it will apply to any extension of time that may occur under the building contract. The other aspect to consider is provisional sums, and again, something that comes up time and time again on building contracts, but can be of particular relevance for cladding contracts because you're dealing with an existing building. And therefore there can be a number of unknowns, particularly if that building was built a large number of years ago. Often cladding contracts are entered into, and whilst there will have been some investigations into the external facade, it won't be known exactly what the build-up behind that is, and therefore we tend to find that costs are kept more under control during building contracts if there are more defined provisional sums at the outset for some of the difficulties that often arise during the process of works. Next, I'm going to consider some of the risks that should be taken into account when agreeing the commercial terms for contracts. The first one is dealing with the design. Due to cladding remedial works being dealing with an existing building, there is a need to mesh the design from however many years ago when the building was first built and the design that's being done by the professional team or by a design and building contractor for the cladding. Given the combination of two sets of designs, it's important that that design risk is clearly defined from early on and it's understood by all parties who that lies with. It's also, I've also found it's often the case that there are elements of CDP when using a traditional building contract because of the degree of the temporary works with the scaffolding and other aspects like sizing cladding panels. Further aspect to consider is the existing building risk and how that's allocated between the parties from the outset. It's understandable for contractors that they are not willing to take on the risk of a building that may have been there for 10 or more years and they don't know what's behind it. But on the other hand, understandably, employers don't want to take on the risk for something that could be obviously seen from a site walk around. Therefore, where the risk lies and who takes on responsibility for what type of things should be something that's considered and discussed as part of the original commercial deal. Sitting over the top of these risks is considering insurance. Normally, parties rely on insurance to provide some protection in the event that certain risks occur. But with the insurance market at the moment, one of the key exclusions is combustibility, which if your building works is entirely around changing the cladding on a building because of the risk of combustibility, may cause some problems with protecting the parties in terms of professional indemnity insurance. Turning to perhaps some slightly more practical aspects, with scaffolding being in existence or cranes or cherry pickers depending on the height of the building and the works that are being carried out, I've often found there's a need for an oversell licence on many of the cladding contracts that I've worked on. And again, it's something that should be considered early on at the contract stage, whether the responsibility and the cost of dealing with this lies with the employer or with the contractor. This also ties in with access difficulties as well as being tall buildings. Often a lot of these buildings are in built up residential areas and therefore access to the site can be very tight. Again, it's something that should be considered, included within employer requirements where possible. And generally it's better if the contractor spends some time considering these things during the tender process. In terms of some of the key documents that are required for cladding contracts, Alison mentioned one of the key ones earlier on, the EWS1 form, and the difficulty in always being able to find a fire engineer in order to sign these off. Given that with most remedial contracts, there will be a fire engineer or a contractor taking on that role in-house, we have found that it's better to decide who will be doing that EWS1 earlier on, and generally for it to be the person who is designing the remedial works or the fire engineering aspects of the remedial works, as they're much more inclined to be willing to sign off their own work when they know exactly where the design process went. We therefore recommend that this is decided at the contract stage and either included within a design and build contractor's contract or within an appointment for an architect. And if it is a traditional build, it may be that the contractor needs to provide certain documents to assist the professional team in compiling the necessary information for an EWS1 form at the end of the works. Another key document for cladding contracts is energy performance certificates. Due to the external facade being replaced, it is possible, depending on the new materials, that the energy performance rating of the building may change. And therefore, I've found in the contracts that I've worked on that as part of the employer requirements, contractor is required to go into individual residence homes or commercial units to carry out energy performance certificates. This obviously needs to be considered in both costings and timescale, as on some of the larger buildings can take some time, and also needs to be some thought put into access arrangements for that and where that responsibility lies. As with all projects, it may be necessary to obtain warranties from key subcontractors or subconsultants. In particular, if there isn't a direct contract relationship between the employer and the fire engineer, it's likely that a warranty may be needed for that. And again, due to a large part of the cost being in the cladding product, it may be that it's necessary to get product guarantees from manufacturers to confirm to employers that they pass the tests that are required.
Thank you very much, Kate. Again, a lot to consider there, a lot for us to get our heads around in the industry and digest that. So our next slice is on claims, limitation, practicalities. Alison's going to speak for 5 or so minutes on limitation, and then Kate will finish with some observations in relation to practicalities that she's seen in the work that she's done. Alison.
Thanks, Martino. Yes, as Martino said, I will talk about limitation and Kate will talk about practicalities. The theme running through both what I say and what Kate says is that actually, in relation to a lot of these fire safety claims relating to cladding, they happened some time ago, or the buildings were built some time ago. And that presents difficulties in terms of limitation, but it also presents difficulties in terms of practicalities for either party to any dispute. In terms of limitation, going back to basics, I want to just mention the 4 real basics for limitation that might apply. And for those of you unfamiliar with this, with the limitation point, the law provides that there's only a certain period of time within which a claim can be brought. And the first basis on which you are likely, or which parties are likely to look at whether a limitation has expired or not, is contract. So in a very simple form, if building owner has a contract with a building contractor, it may have 12 or 6 years from the date of breach in which to bring a claim. How either party determine whether the claim is within or outside the relevant time period is by looking at the execution clause of the contract. And if that has been executed as a deed, it may not always be obvious whether it has or it has not, then there will be 12 years from the breach in which the building owner can bring a claim. If it's not executed as a deed, there will be 6 years. The date of breach is obviously factually determinative in each case. There's no specific set requirement as to when a breach occurred. It will vary from project to project, but it will be at some point during the design and or construction of a building. Next slide, please. The other area where there's a limitation provision is the law of tort. That is where one party owes another a duty of care. So in my example of a building owner and a building contractor, although they're in contract together, the building contractor almost certainly owes the building owner a duty of care in tort as well. And that can sometimes be relevant because the limitation periods can be relevant. Broadly speaking, under the Limitation Act in tort, the normal position is that a party wanting to bring a claim has 6 years from the date on which the damage is suffered. That's not the same as 6 years from the breach of contract. It may be longer. But perhaps what's more important in relation to tort is there is a further extension, potential extension of the limitation period. Under the Limitation Act, Section 14A, in tort, a claim can be brought within 3 years from the date of knowledge or when someone ought to have known about something. And in the sort of claims that we've been talking about, or cladding or fire safety claims, it's quite possible that the date of knowledge can be a lot later than the date in which a contract was breached, for instance. But that does not mean that a claim in tort can be brought at any time. It can't. There's a long stop date of 15 years from when the act or omission actually occurred. Next slide, please. There are 2 other aspects of limitation that are just worth mentioning to you as well, because they have come up in relation to what are perhaps generically called cladding claims. One is the Defective Premises Act of 1972. Under that, there's a duty on certain entities to build dwellings properly, and there's a potential claim by anyone who has a legal interest, broadly speaking, a legal interest in any dwelling, of 6 years from completion. But that can be extended, or is extended, if, for instance, a contractor has come back and undertaken remedial works. In relation to those remedial works, when they're undertaken, the 6 year period, when they're completed, the 6 year period starts all over again. And finally, contribution proceedings. These shouldn't be ignored. Under what is known as the Civil Liability Contribution Act 1978, if parties are liable for the same damage, they can seek a contribution from another party. Now, in simple terms, going back to my building owner, let's say that my building owner pursued a building contractor, a design and build contractor, and obtained either a judgment against that contractor or settled with that contractor. That contractor may feel that an architect was responsible for the problem as much as they were, and that an architect is liable for the same damage. The contractor has 2 years from the judgment or settlement with the building owner in which to bring proceedings against my architect. So you can see that under the Civil Liability Contribution Act, you could be looking at a longer period than I've been talking about in relation to contract or tort or the Defective Premises Act. Next slide, please. A couple of last points to finish on in relation to limitation. Limitation is by its very nature highly complex, and we've spent a lot of time between three of us advising on particular cases as to whether limitation has or is about to expire. One issue that has arisen recently is in relation to Section 32 of the Limitation Act. Section 32 actually sets out bases on which limitation doesn't actually start to run, and it deals with fraud and mistake, but it also deals with deliberate concealment. And you'll see that I've mentioned a case there, which, please note, was at summary judgment stage. There's no final judgment on this, where in 2015, the purchaser of a block of flats was not told that it hadn't met building regulations, and it didn't actually find out until 2018. And the courts have taken the view that it can pursue its limitation argument. There's enough merit in it to pursue it through to a full hearing, despite the fact that the original limitation period had expired before 2015. Again, complex facts. If you want to know more about that, have a look at our blog. There's an article by my colleague Andrew McConnell on that fairly recently. And lastly, what happens if you're close to the limitation period? It's all very well having a deadline, but commercially that's not necessarily in anyone's interest for parties to be rushed into issuing proceedings or defending proceedings. Well, there is such a thing as a standstill agreement, and a standstill agreement is what it says it is. We spend quite a lot of time drafting these. It's an agreement to stand for time to stand still, either for time to be suspended or extended. And there are benefits to this, particularly in cases where parties suspect they might have a claim but don't know for certain, and for defendants to prepare papers to consider whether they have a defence or not. So there are good reasons for both sides to take a deep breath, look at whether they have in fact got a case or a defence, rather than forcing the issue of proceedings and having a timetable which runs away with both parties. There's an opportunity by way of a standstill agreement, as I say, to properly consider and decide whether the matter needs resolving or can be resolved by settlement. That's it on limitation. I'll hand over to Kate now, who will deal with practicalities.
Thanks, Alison. Yes, and as Alison mentioned, some of the difficulties that parties can face in bringing or defending a claim are tied to the fact that the works in question will have been carried out a long time before. The other issue that can create specific difficulties is that often these are multi-party proceedings, either by way of the Contribution Act notice or by way of a claimant claiming against more than one defendant. One of the key difficulties can be in relation to documents. When works were carried out some time ago, it may be that documents are no longer in existence, or it may be that more and more documents are held in hard copy rather than being a soft copy and readily available. Generally, if works are carried out more recently, we find that most of the documents that you're reviewing in disclosure are already held on computers, and therefore can be easier to sort through and look at, whereas with claims and cladding claims, where it's often quite historic, it's more necessary for it to be scanned in and coded and looked at in that way, which can result in more time and expense being incurred for all parties. Another issue in terms of which is impacted by timing is the availability of witnesses. Again, if it's a project that happened in the last year or so, you might expect that one or more of the individuals dealing with the project remain at the organisation, whereas when it's 10, 12 years ago, it's more and more likely that they may have moved on and that you may not have contact details for them. This can be difficult both in terms of a claimant or a defendant having witnesses to provide witness evidence, but also just from internal knowledge of what happened at the time, having those discussions. Normally, before bringing a claim or when a claim arrives on your desk, you would start to sit down with the people who were involved in the project and talk it through and what the issues were, and that may not be possible in these types of claims. As with remedial work contracts, expert availability can be difficult. There are a large number of these claims being dealt with at the moment, and therefore it's key to get, if you're considering bringing a claim or you're faced with defending one, that you get your experts involved early on. This can have other issues with multi-party proceedings, and that there can be a large number of experts that need to be involved. If you have a matter where you've got the main contractor, various subcontractors, an architect, an improved inspector, it may be that each of those parties requires an expert of their own discipline, and that other parties decide they also need a report from someone of those disciplines to push back against it, and that can end resulting in large amounts of time and cost going into expert reports. And finally, investigations can be a lot more challenging when you've got a building that is still in use, whether it's a university or a residential block or a hospital, carrying out intrusive investigations in order to assess what was the actual build-up of the building that was completed 10, 12 years ago can be more difficult.
Thank you very much, Kate. Well, I said about 45 minutes and we're spot on, so well done. Now, we've had a few questions in. So the first one, if I can direct this to Alison, the question I have is, what is an external wall for the purposes of the ban on combustible materials?
Well, the definition of external wall in the amendments to the building regulations, the 2018 version, was anything located within any space forming part of the wall, any decoration or other finish applied to any external but not internal surface, any windows and doors, any part of a roof pitched at an angle of more than 70 degrees. It goes on to talk about other aspects of it. And it also talks about attachments to external walls, including a balcony, a device for reducing heat gain, about which there's been some debate within, well, a judicial review from the British Blind and Shutter Association, who managed to get that part of the regulations removed. But the proposal in the consultation that I talked about earlier in relation to lowering the ban on combustible cladding also intends to bring that back in again. And finally, a specified attachment is also a solar panel. So it's quite wide ranging as to what an external wall is.
Okay, thank you, Alison. Another question. This one looks quite topical. Kate, I think this one's for you. How is COVID-19 impacting cladding remedial works?
Thanks, Martino. Yeah, it seems that in the last year we've started with cladding being the key thing in construction mind, and then COVID obviously has brought another issue to deal with. The government guidance all throughout COVID-19 was very much that construction site continue, and that was particularly the case in relation to cladding, and that point was made a number of times. In terms of where I've got clients where they've got cladding works ongoing, there hasn't been much of a change. Some of them there was a bit of a break or a shutdown for a short period, but that's continued. But in terms of the cladding contracts that I'm agreeing now, there very much is a emphasis on both sides to think about how COVID-19 is going to impact it and where that risk is going to fall in terms of ordering materials and in terms of what happens if there's a local lockdown. And it's very much within both employers and contractors' tender documents, something that they're trying to establish the risk and who's going to deal with that from an early stage.
Okay, thank you very much. Another question, one for you, I think, Alison. Just on the EWS1 forms, as far as you are aware, are there any conversations being had around RICS withdrawing them, given that professional indemnity insurers are looking to remove any cover for them?
Well, yes, I've seen reference in the press to perhaps not professional indemnity insurers, but to some legal advisors who act for professional indemnity insurers, suggesting that not so much that cover be removed, but that fire safety experts be very careful in terms of actually issuing of the certificates or the forms. I also saw that there was a question about an EWS 2 form further down. I'm not actually aware of an EWS 2 form. I am aware that there are concerns about EWS 1 forms, and I anticipate, but I have no evidence to support this, that the government and the industry and the insurers will probably try to get together to reach a solution, bearing in mind how seriously the government regards this whole issue and how many people are potentially affected by being unable to either remortgage or sell properties at the moment.
Okay, thank you, Alison. And a related question, and I'll link it up with that. So for you again, Alison, the questioner says, I understand that there is a difficulty in obtaining signed EWS1 forms, and I've heard of the emergence of EWS2 forms. How do these forms differ, if at all?
Well, I haven't come across an EWS2 form as such. Have you, Kate? No, I haven't heard of them. I know there's concern about the EWS1 form, but I wasn't aware of the emergence of an EWS2 form at this stage. I would have anticipate that I can't see how a EWS2 form would operate in a way that would alter the concerns that have been expressed by an EWS1 form.
Okay. Well, I think conscious of time, we're pushing close to 5 o'clock. So I think that's probably conclude the questions. And just leaves me to mention our up and coming webinars. We've got the modern methods of construction topical, links on to this. So that's being delivered by my fellow partner, Stuart Pemble, as the chair, with Caroline Hanratty, Emma Nash and Alison on the 19th of November. So please do register for that. Reference has been made to our construction blogs, a useful repository of, we hope, helpful hints and tips and practical guidance. So feel free to dip into that. And at the end of this, there's an opportunity to give your feedback, including if there are any particular areas, topics, issues that you think would be of interest for us to cover. We'll certainly take that on board and look to cover that. So thank you all very much for joining Mills and Reeve. Thank you to Alison and Kate for being our speakers and presenters today. And I wish you all a very good evening. Goodbye.